Welcome back to Radio Entrepreneurs. I'm Jonathan Freedman, and our next guest is Denise Chicoine, partner of the Wagner Law Group. Welcome to Radio Entrepreneurs.
Good morning. Thank you for having me, Jonathan.
It's a pleasure to have you on. I know that you deal with all things related to legal agreements in organizations, and this morning you want to talk about something that's highly topical. That is the topic of non-compete agreements.
Yes, I've been doing employment law for over 30 years, and so I've witnessed a lot of change in the field. And in 2018, there was a big change here in Massachusetts that really made it more difficult for companies to put non-compete agreements in place.
And that effectively, I don't know if the law in 2018 banned non-compete agreements, but made it so that it would be very specific circumstances under which you can enforce a non-compete. Is that the case?
Yes, exactly. So in 2018, the Massachusetts legislature required that companies seeking to put non-competes in place had to be very specific about what was covered, the geographic area. It couldn't be for more than a year, the specific aspect of whatever industry was being dealt with. And probably most significantly, the law requires that the company pay fair and reasonable compensation, which is now defined essentially as 50% of the employee's salary. So if a company is trying to impose a non-compete for a year, it would require 6 months of severance.
Okay. And all of this obviously put in place to be able to protect or provide for, I probably should say more accurately, employees to have the opportunity to be gainfully employed and seek employment. And I understand a lot of it was based on, well, you can't block from somebody from being in an industry that they know everything about. But obviously, the line gets drawn in terms of they can't take trade secrets or information or perhaps, and maybe this is a question for you, contacts from their prior employment. So it seems to me that we're navigating a very murky sort of situation, right? Because you work in an industry for many years. It's all the contacts that you may have, maybe people who you've been in touch with. So how does that fare into the sort of landscape of the non-compete?
Right. So non-competes always were meant to protect a company's goodwill. So it's something that the company gives the employee, some type of training, or like certainly the classic example of a trade secret, a particular software code. But the employee's own skills and own contacts generally belong to the employee. But companies can protect those relationships. So say in the example of a salesperson, that company could say, once you've worked for us, you can't now contact this defined list of customers for a period of 1 or even 2 years, because non-solicitation agreements, what we're talking about here, preventing contact with customers or prior clients, those are outside the scope of the law that was passed in 2018.
Now, let's fast forward to recently. There's been some changes on a federal level in terms of non-compete. Is that correct? That there's been
Yes, you're very tuned in. The Federal Trade Commission in April of last year outlawed non-competes, like retroactively and going forward, and said that this was just not a good business practice. In fact, the FTC, the Federal Trade Commission, went so far as to say that it was an unfair and deceptive act for a company to attempt to impose non-competes. So it was a very sweeping ruling, and certainly, upset certain groups that then appealed it. And the district court in the Fifth Circuit in Texas imposed a nationwide ban, saying that the FTC had exceeded its authority. The FTC appealed. That case is pending, but perhaps with the change in administration, there may be, a different direction taken on whether that fight will continue. So as it stands right now, that nationwide ban is stayed. It can't be, it's not in effect right now.
So this is one of those interesting things that I think challenges entrepreneurs and smaller companies in general. When you've got these moving targets that are continually changing, and where people like yourselves come in to guide people and give them some guidance, it seems to me that the challenge is, how do you stay up on if you're not in the field, so to speak. You're not, exposed to the changes and stays and things that happen fairly rapidly in these cases. How does one sort of stay up on what can I do and what can I put in place and how do I protect my company and how do I protect myself and my organization if there's a continual moving landscape?
That's true. And so companies that have concerns about their intellectual property, about if their whole business model is based on sales relationships, it is worthwhile. Nobody wants to hear that lawyers are helpful, but really a lawyer could be a valuable resource just to have a check-in, once every 6 months or a year to say, and a lawyer that knows the person's business could say, here's what you should be thinking about.
So it seemed to me, or I guess my question is, what happens in the event of a stay? So does that create much more uncertainty in terms of what you can and can't do? Or does it absolutely say that non-competes can be enforced? Or is that left now back to the state courts to make a determination in Massachusetts, for example, if there is a dispute over a non-compete?
Yes, it's all of the above, right? It certainly does create uncertainty. I would not advise any business to assume that all non-competes, are worth entering into. For many years, they've always been very difficult to enforce. And to your last point, it does throw it back to each state and whatever the state laws are. There are some states that have been ahead of Massachusetts and completely banned non-competes, for example, California. And there are some states that allow them freely to be imposed. So it really does depend on where the company is operating.
So I know we're sort of entering perhaps into a little bit of a different subject area or maybe adjacent subject area. What is some high level advice that you would suggest that business owners, entrepreneurs think about in the context of putting employment agreements into place and that area of non-compete language to protect themselves and their companies?
I would say non-competes should be rarely used. It's only for like the most high level executive, perhaps, someone that helped found the business that really becomes the face of the company. And if that person leaves, you might want to think about higher level restrictions. I think for most companies, what will be more enforceable and more valuable is this field of what we were talking about, non-solicitations, that the company can define what clients or vendors or customers are off limits going forward for a period of 1 to 2 years. And, that can be done as part of even an offer letter. It's not subject to the same requirement that a huge amount of compensation be paid for it. Or it can be done as when someone's separating from the company, if any severance is being paid. And the non-solicitation can also include, working with existing employees. So the company doesn't want somebody poaching employees away after they leave. And those are, I think, address a lot of small companies or any size companies' immediate concerns.
So, conventional wisdom would tell you it's a lot easier to negotiate something like that on somebody's way into the organization as opposed to their way out of the organization. But one of the things that I'm hearing you say is that you can put a caveat in place relative to a separation agreement, which says, we will provide you with this if you're willing to do that. I.e., we'll provide you with compensation if you will not solicit, this group of customers or this segment of customer. That the way I'm hearing it correctly?
Yes, that's right. So it can be, you're right, it's better to negotiate it up front. But for companies, maybe the employee has been there a long time and the position has evolved and it wasn't needed initially, that can be dealt with when the person is leaving. Of course, then it's, as you said, a negotiation. You're going to have to pay something for it.
Understood. Now, one of the things you talked about non-solicitation and defining customers, can it be cut? Are those usually down to specific, or can it be broad in terms of within a geography, within a certain market segment, within a certain size, as opposed to named companies?
Right. So for non-solicitation agreements, it can be a particular segment of the industry. It doesn't have to necessarily be named contacts. And it can be, yes, just as you said, based on geography or based on, sometimes you see in the agreements, anyone that the employee has dealt with in the prior 2 years of their employment in the business context.
Yeah, and I would think today with the use of technology, contact management software or CRM software, there's probably a lot more clarity as to what the activity might be, as opposed to what historically was the case of sort of painting these very wide swaths of, you can't speak to anybody within a 100-mile geography who may have a child between the ages of 0 and 100, and those types of things. So it
Right.
would seem to me that
Certainly.
today they could be much more defined.
Exactly. And narrowly defined is more enforceable because both parties understand what the scope is.
Excellent. Well, interesting information. You've given us lots to think about, and hopefully our listeners too. And in the event that somebody wants to talk more about non-compete agreements and how to perhaps protect themselves, or in the case of an employee, what they might be looking for, or some guidance. Denise, what's the best way for people to reach out to you to get in touch with you?
I'm happy to have people email me at the Wagner Law Group. So it's just D Chicoine at Wagner Law Group, or you can find me on LinkedIn.
Wonderful. Our guest has been Denise Chicoine, partner at the Wagner Law Group, and we thank you very much for joining us on Radio Entrepreneurs.